Welcome home. This is Tampa Home Talk, and I'm your host, Katrina Madewell. Welcome back to another exciting edition here of Tampa Home Talk, and I'm super stoked to welcome back Mr. George Root. Welcome.
Thank you, Katrina. It's
Are you
great
excited
to be
back?
Absolutely.
With the Stockholm group. He's all prepped and ready for the show this morning. And we've had you on the show before, so if you're just now tuning in or you haven't heard George before on the radio with us, he is an HOA attorney expert. So that's what you do.
Yeah, I am. I've been practicing in this area for about 15 years. I grew up in rural West Tennessee on a farm and came down here originally to go to St. Leo University. And then after about 5 years in the Army, I came back here to go to law school and been practicing condo HOA law ever since, about 15 plus years.
Those are so different. Like growing up on a farm in Tennessee compared to like the HOA law world, that's so different.
And when I explained to my dad what I did for a living, he didn't understand it. You mean you can tell people what to do with their own property? Have to park in a certain place.
Didn't even understand HOA, let alone why you would need an attorney for it, right?
Yeah, absolutely.
And you represent mostly the communities, right? The HOA communities, not so much homeowners on that side.
So I represent probably about 130 or so condos and HOAs around Florida. Most of them are within the 5 or 6 counties around Tampa Bay. And then we have 4 attorneys that do first-party property litigation for insurance claims where they're denied or not fully paid. And we've got one guy that does medical malpractice, plaintiff's work, and nursing home abuse and neglect, stuff like that.
So you're the HOA in-house counsel, on staff, on retainer type attorney, right? That helps with all the stuff that the HOA should not be doing that some of them try to do, right?
Absolutely.
We could probably do a whole show just on that, like the stuff the HOA people should not be doing.
So we do their collection work. We do violation enforcement. I like to think of myself as a coach, make sure they stay in compliance with the state statutes, and there's a ton of them.
Yes.
And their governing documents. It's almost like you have to be a lawyer to figure out how to run an association.
Yeah, I mean, it's a lot for sure. And I think they definitely need counsel, somebody like you on staff, because they are not attorneys and they don't know all the laws that go into that. And sometimes, these agents or CAM managers or even people on the board of directors are not they're even less educated, I think, than a lot of agents are.
And they keep adding more stuff to the statute and changing the regulations every year. So I study it every day for the last 15 years, and there's still things that I learn that are new every day. I couldn't imagine coming into a board position with not having a background in this industry and trying to do it without relying on professionals, whether it's your realtor or your attorney or your accountant. One of the things to protect yourself from liability is you have to act with the care of an ordinary, prudent person, and an additional shield for you is to rely on experts and reports instead of just making uninformed decisions. It's
such a specialized area of practice, too. Like, I think, and I talk about that all the time, because attorneys, like agents, you guys have a little bit of a bad rap, right? Because there's so many of us, and the general population doesn't like either one of us. And so I tell people that you don't need a really good real estate broker or a really good attorney until you need them. And then you want the 80-20 principle. You want someone that is in the top 20% of their field that knows that area of law very well. And I think especially in the law world, if you have, the master of all, or the jack of all trades, the master of none, I don't know how comfortable I would be with that if I had to retain an attorney.
100% agree, and I try not to dabble in things I'm uncomfortable with. I try to stay in my lane. By way of example, if somebody comes to me with a construction defect issue, then I bring in co-counsel. Or if it's a really nuanced land use issue, then I'll refer them to someone who's very good in that area. So I'm trying to be kind of like a counselor they can call and get advice, but I'm not trying to do all of it. Just connect them with the right people.
Well, because that's one more area of law you have to be familiar with in order to be a true, a true fiduciary, I guess, right? For the client is a good way to say it. So today's show we have lined up for you is going to be all about 10 smart questions you can ask an attorney who specializes in CAM or HOA type law.
Awesome.
So I thought it was such a good area of practice that you can answer, and it'll be just good information for the public, of course. So what are some of the most common legal issues that you see HOAs and condo associations face? I'm sure you have like one war story after another that you could tell.
one of the hot button issues now is records inspections. People disagree, and in our climate, locally, state, federally, people are used to they want to get their way or their opinion, and sometimes if the board doesn't move in a direction they want to do, they're doing records inspection requests, a lot of things. Sometimes it's a legitimate attempt to get a board to be more transparent. Sometimes it's kind of harassment. Mm-hmm. And the state is taking greater regulatory control over that kind of thing. And I think
How so? What do you mean when you say that?
There's greater penalties, civil and criminal penalties for destroying records or purposely withholding them and not turning them over. And it's such a quick turnaround time on these records. And I think there's a lot of management companies and boards that aren't properly storing them. If you're doing it right, then it's click a few buttons and here you go, here's everything. Mm-hmm. But not everybody is retaining the records in a manner that it can be easily transmitted to the requester. And there's a lot of damages to the association if there's abusive records requests. There could be a $500 fine plus prevailing party attorney's fees and litigation. And there's civil and criminal penalties for the board members or managers that purposely destroy or withhold those.
Wow. And I think it's important that we have protection for the general consumer on those things, especially with things like Senate Bill 4D passing and, all these huge requirements of associations now to make sure that these properties are kept in good condition that doesn't harm the people that live there or the general public. So I think it's important that they have that. So how, in your opinion, like representing a lot of these HOAs and I guess maybe even come from the place of if you had a new community that was looking to retain you and understanding that some of these changes are taking effect where they have to have their records in place, what kind of craziness do you see where they think everything's fine, but they're really not as organized as they should be in terms of the financials?
First, you mentioned turnover. It's pretty important that when you do take over from the developer that you evaluate your infrastructure, see if there's any issues with it. You want to evaluate, make sure you got everything from the developer you're supposed to get. All the time I have to send letters to developer, hey, we don't have the turnover audit. We're missing these 4 documents. You did deficit funding, you owe us money, that kind of thing. And so we're having to go to the developers and try to extract these things from them. One of the important changes in the last couple of years that they made with condos and HOAs is now they require board members to take a 4-hour board certification course. Previously, you could waive out of that requirement and just sign a piece of paper saying that you are going to do your job, essentially. So,
well, I think that's good. I mean, I think and who actually teaches that? Like, where do they get that information or that required training? Your company does that?
I teach these. Yes, they're free.
That's good.
Don't cost you anything. A lot of my peers do the same thing. You're required to take it once you get on the board, and once you take it, it's good for the term of your uninterrupted service, I think, for like 4 years.
I think it's fantastic because especially if people have never served in that capacity, and I see it all the time where people are, hey, I'm on the board or I'm this or I'm that, but they really don't have any experience or qualifications to even warrant them holding that position. So I'd love to see that the state's mandated that now.
Absolutely, and you're absolutely right. These people are managing $500,000, $1 million budgets, and they may not have an accounting background, no legal background. Who knows?
No
what their
business background,
right.
Some of them at all. Like, so yeah, some of them, you can see just like a plant farmer. Yeah, I'm on the board.
Like
somebody like your dad, right?
Right. Putting my dad on the board would probably not be a good idea.
Yeah.
No offense, Dad.
No, but I'm saying like the point is like if he had an interest and he wanted to do it, at least that 4-hour training would give him some direction to run in.
Absolutely.
So I think it's smart. I think it's a great idea. So how should the board handle any disputes between homeowners and associations in a way that's fair to everybody and then also legally, right? From that perspective, you have to advise people all the time that you represent on the HOAs, but what are some of the disputes that you see, I guess? And let's talk about the best way that people should handle that, because if you've ever been in litigation, the best way to handle any type of dispute is amicably, quickly, to something that everybody can live with, right? It's a fair way to say it. So what are some of the things you see where people are disagreeing, like especially like homeowners or people that live in the community with the HOA? Like where do people have major impasses that they probably should spend a little more time slowing down to work it out?
Some people get frustrated because they want to make architectural changes to their property and they either don't go through the architectural committee or their plans get rejected. And I think both on the condo and HOA side, there is a pretty good pre-suit process. We essentially send out a 20-day offer to mediate letter. We get people in a room together with a mediator, and I would say 80-90% of the conflicts work themselves out. And you're supposed to technically do that before you litigate anything. So that I think that helps cut down on some of the litigation.
And I think sometimes people that do this don't understand what litigation is and how long that can tie up. And actually, even if you're suing your HOA, you're theoretically suing yourself because those costs have to be passed on to the owners of the community. So the architectural review changes, that's a big one that you see people disagreeing on. I
see a lot of that. And then some people just don't agree with the business decisions that the board makes. And in today's climate where everybody has instant access to each other, we get flooded with emails. I spend half my day reading nasty, vitriolic emails back and forth, and I'm finally learning how to turn down the temperature and approach it in a different way to kind of tamp down that fire, because it doesn't accomplish anything for that individual homeowner or the board.
Are you using ChatGPT to help you in that at all?
A little bit. We have some pretty good forms for our letters. And a lot of what a lawyer does is just quoting a statute verbatim and using your own words to tell them what that means. So I don't really need ChatGPT a lot.
I think the approach is pretty good, right? So even though you're quoting the law, I know myself, even when I've been responding to stuff like with a client and have a great relationship, but something's like off and I don't want to sound snarky when I'm responding, I'll literally put it into ChatGPT and I'll say, this is what my seller said. Here's how I want to respond. What's your feedback? And it's pretty honest. Like sometimes the feedback it gives you, and then it'll give you like suggestions to kind of soften your approach, which can be good for somebody like me and certainly a lot of attorneys. Soften your approach so that it's more, it's a better approach.
I've still got a lot to learn. I got to dig into it more. I think what I utilize it the most for is helping me find the primary sources quicker. So if I put the right prompts in, it gives me the statute, it gives me a website, and I can find that primary source a lot quicker.
Really fast, It's like the best assistant ever, but I have to say I've used it in a multitude of communications like that, and it will, and then of course you can change it and add a little bit of your own, but it's the feedback it gives sometimes, like I wish I had my phone, I would read like the feedback it's giving me. It's kind of like reprimanding me almost.
One of my peers at a conference we had last year displayed this one program. I got to get the name of it, but it spits out like a perfect PowerPoint presentation. Like really quickly, and you don't have to do a lot of editing at on the back end.
The time frame that it takes to just, like all the brain power that it would require to do some of these things, like even researching a statute, you can remove all that and just verify and source material quickly.
Absolutely.
So are you the guy that I would call when I've been paying $400 or $500 a month for my condo, my HOA fees. And now because it's an old condo and it could fall through the ground and fall apart like it did in Miami, they want X amount of dollars. What right or what do we have to do if they say, now we need an extra $1,000 a month?
It's tough. So what you're talking about is Surfside, and the legislative response to that was a thing called SEERS, or Structural Integrity Reserve Study, and then milestone studies. And I'll get rid of the legalese. It's having condos and look closer at the buildings. And they're ones, it doesn't apply to every condo. It's ones that are 3 habitable stories and above. And you get these reports back, and what it's resulting in is condominiums that have not fully funded their reserves for years. They're seeing a massive increase in spike in assessments. So if you get that bill and you don't know what to do, I would reach out to the board and see if there's payment plan options, see if there's funding options through loans. The legislature just changed some rules to make it easier for associations and boards to vote to take out loans to fund those repairs, and that'll lower the impact to individual unit owners more so than a special assessment.
So that's the reason why we see all of these for sale signs.
I mean, here's the thing, Pat. Going back to Senate Bill 40 and in the milestone reserve, all the inspections that are required to make sure that they have enough money to make these repairs when big expenses come up. If you remember Leo talking about that as well on the show, we were talking about how the board members basically of that community sort of kick the can down the road. And there was a lot of engineering structural type things that you could, like somebody like Leo would have a field day walking through a place like that before it collapsed. And that's a prime example of the board of directors that either don't want to make anybody mad or they don't want to pass on the expense, but they're necessary expenses, which is why that whole thing collapsed. And that's subsequently why that legislation came into place. So what you're talking about in terms of those special assessments are because it's required, but then, the pendulum swings one way and then it swings back a little harder. And so going back to your thought, Pat, on what you said is there has been a lot of these deferred maintenance for a long time. And now these communities are required by statute to do it legally. They have to do it. They're required to do it. And so now they have these big bills in terms of special assessments, or if they're not terrible, they have or increasing their monthly expenses. So that's why so many of them are so expensive and they've become unaffordable for a lot of older people, which is sad. And honestly, the Sadowski Fund, I think, should be helping on some of those things because that particular fund was meant to be in place for affordable housing. And I think there's way too many seniors, for example, in condos that are, shocked, but they don't even know that all this stuff happened. And now they're just getting these big bills that they can't afford. And that's the purpose of that fund. And so instead of letting the state sweep it for other things, they should be utilizing it for that. But it's hard. Like I was on Shriner's show, Pat, I don't know if you remember, and there was a caller that called in asking about the Sadowski Fund. And I thought, wow, people don't even really know about that. It's so great that this guy.
Much about it.
So the Sadowski Fund, every time a property changes hands, you know how we have all the tax stamps on the deed and on the mortgage and stuff, there's a portion of that gets funded to the Sadowski Fund, and it's meant for affordable housing. So a lot of the first-time homebuyer programs, affordability for senior housing, a lot of the Section 8 stuff gets funded through that. So it's meant to help people that need it. And so honestly, I think the Sadowski Fund should be funding some of this stuff. The problem is, like, for somebody like me, I try to cover all this stuff in and around the homeowner space. And I've tried multiple times to get in touch with someone at Tallahassee that has that budget so I could look at it to see where the money is going, where they're sweeping it, because I'm genuinely curious about it. And I can't, it's something I'm going to have to get the commissioners involved to kind of chase the right trail, because otherwise a layperson like me doesn't know where and how to get that information. But it's pretty interesting. If you haven't had a chance to get on that rabbit hole and read about it, you should.
I've got homework now. Thank you,
Yes,
Katrina.
definitely. So if you can help me connect with the right people, I'd love to review their budget, to see where the money is going and how they're doing it. And it takes people like us to lobby for that stuff so that money does go to the right place and not get swept to wherever they feel like sending it.
Speaking of lobbying, luckily, my fellow peers and practitioners around the state that do what I do have successfully pushed some glitch bills that have kind of fixed some of the errors with, or some of the issues we've had with Sears and Milestone to try to tamp down some of the dire economic impacts that are facing and pricing some of these people out of their units. And so I think there's some options they should definitely discuss with really good management and really good attorneys and accountants to make sure that they're taking all the right approaches to kind of, the costs are going to go up.
Right.
For years, even before this legislation, I've had clients that I've tried really hard to increase their budgets so they can do the right thing as far as taking care of their common areas. And as soon as they pass a budget that's adequate for what they need, they get recalled or voted out of office and then bring it back down to the area it shouldn't be to begin with.
But because people are not looking at it big picture, they're looking at it, this is going to cost me $100 or $200 or however much more a month. In some cases, it's double, on some of these HOAs. Well, I'm curious, what kind of things are you guys lobbying about? You said some of these little gaps that you're finding, because again, when that pendulum swings back, you find some of these little gaps and holes that you don't know unless you're an attorney kind of dealing with these things, or the layperson that's involved in the middle of it.
Some of the inspections, as I mentioned earlier, are tied to how tall your building is. And so it didn't define it real well. So we were having to go to the Florida code, and we were trying to determine whether a parking garage on the first floor counts as one of the floors. And so they clarified that and says it has to be habitable floors. Okay. So if it's open space.
Even if it's on the beach?
Even if it's on a beach, it has to be habitable stories. So that was a big change. There's all kinds of clarifications, too. They're giving you more time to get certain inspections done, that kind of thing. Now,
George, do you think that this type of legislation is also going to trickle into the units that are less than 3 stories? Because there's been a lot of word that it's going to kind of trickle down to all of them in communities and also all across the U.S., not just Florida. Have you heard anything about any of that?
I don't know. If you've got one guy in South Florida saying he's going to get rid of condos and HOAs, I don't see that ever happening. Because
it's not possible.
No, I mean, the government would have to take over these HOAs.
If you got problems now,
right.
imagine that.
So you see these kind of clickbait, if you will. News articles come out on some of those things, but the real work gets done with. I'm a member of Community Association Institute, and we've got a pretty good lobbyist team that tries to push for things that make sense for owners and associations and people in the industry. And there's other trade organizations out there that push hard to take care of condos and HOAs and make sure owners are protected and make sure that, you know, it's tough. There's so much regulation of the industry, and arguably it's needed in some areas, that it's a lot to stay on top of and make sure you're in your compliance. On a day-to-day basis, I imagine every board out there violates some part of the statute because there's so many things to stay on top of. It's tough.
Right, right. So I'd love to talk about the limits of the HOA's authority when it comes to enforcing some of the rules, when it comes to issuing some of the fines and this sort of stuff that you see. I mean, I imagine there's some statute around this, but what's their limitations? What can they do? What can they not do?
Your training wheels, what you're allowed to do is in your governing documents. And, you know, sometimes your statutes will supersede it. You mentioned fining. So fining, for instance, they amend that statute on both sides, condo and HOA side, almost every year. And it's getting better. I've never been a fan of fining. I understand it. You know, the purpose of the fine is so you're not having to hire an attorney to pursue this violation enforcement. But then when I have to go collect that fine, there's more vulnerabilities in that type of case than many of the other cases I litigate. So I've never been a big fan of fining. And, you know, my advice to clients are if they remedy the violation eventually, then let's reduce or take this off the table, because the goal isn't punishment. The goal is to remedy the violation and get folks to follow the covenants and the rules and restrictions.
How do you I'm sure you've seen this. How do you handle when, for example, a homeowner feels like they are being singled out? Right. So let's look at even like the communities, like where there's homes and they want the grass to look a certain way, or, you know, the grass is not up to par, it's dead. They don't like the landscaping. They want to pressure wash the sidewalk and the driveway, whatever it is. When you have people that feel like literally their property or them as people are being singled out, and they're like, well, what about Susie and John down the street? Their driveway looks way worse than mine. How do you deal with that kind of stuff?
I'm glad you mentioned that, because you're alluding to the affirmative defenses we see in litigation the most: waiver and selective enforcement. And, you know, which happens,
don't you think?
I think it does. One of the ways we combat those affirmative defenses is you have a violation enforcement policy. You have routine inspections. You send letters to everybody, you know, several warning letters before you get to the attorney or fining. And one thing I like to do when I have a really good management company or association is when they raise those claims, I'm like, here's 1,000 letters. Here's who all we sent them to. Thank you for letting us know about this new one. We'll make sure they get one as well if they're not in here. And so if you have a really thorough management company, then you don't have to worry about selective enforcement as much.
Have you had communities that you've come in as the attorney for, you know, the counsel for the HOA, and that they didn't operate like that before?
There's a lot of self-managed company associations that aren't operating the right way. And I've definitely had some cases where I got out of quickly because I realized this was selective enforcement or waiver, and this is a loser. I'm not, you know, for you. And I try to get them out of that, or tell them, hey, you need to shut this down. This is not a winning case for you.
You try to coach them, and hey, you can't do this. Here's why.
I'm not going to drive a case to run up attorney's fees.
Yeah.
I'm looking to have clients for 20 years and keep their costs super low. And I mean, sometimes you have to litigate. Sometimes you do have to spend money, but I'm not one that's going to drive litigation just to make my paycheck.
80-20 principle. The good ones are in the top 20%. They understand it.
Can I ask you this? I noticed, and you probably do too, because of the price of everything living in a home, that kids are coming back home. They just can't afford an apartment. They can't afford a condo. Are you getting complaints from HOAs of too many vehicles in front of the property?
That happens a lot.
It happens a lot in my neighborhood.
That's got to be happening more, I would think, than it was before.
And also the second question is, can you tell me the difference between an HOA and a tax-exempt neighborhood? Because I'm in a tax-exempt. We don't have an HOA.
What do you mean a tax-exempt neighborhood?
I might be calling it the wrong.
Like a CDD, maybe?
It is. It's not an HOA, but it's the one step down where the association, we have a treasurer and a president. They can't enforce anything, but they do take $100 a month for the landscaping and things like that.
Well, I think
what is that called?
he's in an older community
Right.
in Tampa, so it was like before a lot of these communities were written with bylaws and CDDs and all that stuff.
And right now we're getting ready to maybe lose our group. And if we do, we have to be put in another neighborhood that has an HOA. They're going to take us over.
Those are voluntary HOAs, civic organizations, and you're volunteering to be a part of it, and you're volunteering to pay your assessments. If you didn't pay the assessments, they're not going to be able to come after you and lien your home and that kind of thing. You have to sign consent and joinders to join a deed-restricted community. I've got some communities I represent where the developers...
That's exactly what it is, deed restricted.
Yeah. So I've got deed-restricted communities where developers developed it wrong. They started selling units before they recorded all their governing documents. And so if they sell a unit before they're recorded, that unit's not bound by those covenants. So you got to watch out for that.
Now you've got little sections of the community that are completely exempt and others that are not.
I had to keep a chart on my desk, color-coded chart, which ones we were allowed to send certain letters to and which ones we had to leave alone. And eventually you try to get people to sign a consent and joinder and willingly join so that eventually you can get 100% participation.
And I've lived in both, HOAs and the one I'm in now. And the one I'm in now, people park their vehicle up on the grass. They leave their garbage cans out by the street or next to their house. No one can say a word about that.
I'm glad you mentioned parking because this is one of the opinion letters I get a lot recently. We get a lot of street parking. What do we do about it? Our governing documents say that people aren't allowed to park in the street. Well, who owns it? Is it
Or have a commercial vehicle.
Right.
Well, in some of the county, like in the municipalities, it's in their not outside of the HOA. It's in their rules within like law enforcement to not let people street park because fire trucks might not be able to get through if people are parked on both sides.
It is so hard to get the municipalities to come in and issue citations. And these clients, their governing documents will say that they're allowed to enforce parking, but they don't own the streets. It's dedicated to the public. It's the county. And I try to make the analogy to them. You can't go over to Walmart's parking lot and give somebody a citation for parking in the wrong spot, and you can't pursue your restrictions because you don't own these streets. I think there's some real vulnerability there, and I've looked at some cases that seem to indicate if you don't own the streets, if they're public, that covenant, even though it says you can't park there, you really can't do much about it.
That's a great question, Pat, and a good point to talk about. So what as an attorney that tries to find resolution, right, for everybody involved, what are your thoughts on that? Pat mentioned, he's not wrong about a lot of these kids or grown adults, young adults that are moving back home because the cost of living is so expensive.
It's sometimes associations, whether it's a condo or HOA, will have occupancy limits as far as how many heartbeats per room, that kind of stuff. There's other things that you could do to kind of prevent some of that. Obviously, if it's got strict parking regulations, the associations, even if it's public streets, they're going to be able to enforce their covenants for the lots and the common areas. So you can adopt a towing and parking enforcement policy. There's some things you can do to curb that particular issue. I've had issues recently with teens or early 20s living at home getting into gunfights in the middle of the neighborhood. I literally have to send violation warning letters telling people that shooting each other on the common areas is a violation of governing documents.
Oh my gosh. You can't even make this stuff up.
Well, I know that one of the homes in my neighborhood, it's a 3-bedroom, 6 cars. And a 3-bedroom. And then Town and Country, if you haven't driven through there, it has gone completely insane. They have taken patios, garages, turned them into rooms. And they're like boarding houses all through Town and Country.
I think with the whole parking situation, and sometimes it's just a lot of cars, right? Like I moved from the last house because that was such a choke point for us. Having grown kids that drove, between my husband and I, we had 3 different vehicles. One of our big truck we parked at another property just because it was too many cars, 2-car garage, you got 4 cars, that's a lot. And you're constantly playing this musical car game. I think a good solution to this, right, like even in a neighborhood, like a CDD neighborhood, would be to sort of extend the drive space on each side. And you could do that and make it look very nice by way of pavers and things like that. Then you don't have people parking on the grass and you can sort of solve
they've been doing that.
issues.
They've been paving the whole front yard.
No, I'm not talking about that.
But no, they have in Town and Country. If you go through there, they have concreted, put pavers down, so there's no grass so the cars can park everywhere.
So they're going to have to go to their municipality and get some codes passed that kind of cut down on some of that. What you're talking about, the driveway extensions, a lot of the governing documents for HOAs I represent up here, they do allow you to extend so many feet on each side as long as you're not getting into a setback area or encroaching on your neighbor's land.
And the big patio pavers are a good way to do that. I mean, we did that at our house before the one we moved at when our kids started driving. It was really nice, like 24 by 24 stones, and it was just very nicely laid, and it worked out great because you could park some on the one side and you could get around cars on the other. So
I'm dreading when my oldest turns 16 in 6 years, having to find a place to park her car. Very limited.
It's a real thing when you're doing the whole the car shuffle, you know, in the morning or at night, and then everybody's mad and you get people working different schedules. It's not fun.
That's tough.
Well, at least you don't live in South Tampa.
I'm in Old Carrollwood, so.
Yeah, Pat knows. He's in that area too. So when you think about the HOA taking its, different steps to protect themselves from liability, what kind of liability do you see, and what are some of the things they should do to protect themselves?
Number one, make sure you have all the appropriate insurance coverage in place. I would not get on a board without there being some D&O coverage in place, and I would also ask about the policy limits and stuff like that. You got to get fidelity bonding for folks that put their hands on the money, general liability for the association. The standard in Florida is you just got to act with the care of an ordinarily prudent person. That's not a terribly high bar. So folks are going to have a hard time piercing the corporate veil and coming after you personally, as long as you're acting with ordinary prudence and acting with the care of someone in a similar situation. As long as you're not being criminal, grossly negligent, stuff like that, you're going to have a really hard time having the corporate veil pierced.
Yeah, don't be crooked with the money. What type of things should they look at in terms of coverage? Like, what's enough? How does a layperson look at that?
Well, luckily, I have 4 ladies, an all-female first-party property group in my firm that knows insurance inside and out. So when I get a lot of insurance questions, I just get to knock on the door next door. Also, I look at the governing documents. There's usually an insurance section, and it tells you minimum coverage requirements and minimum policies. On the HOA side, there's not many statutory mandates other than fidelity bonding for those that have their hands on the money. The condo side is much more driven by the statute. It tells you what areas an owner covers versus the HOA or the condominium. That's 718, 111, 11F3. Wow. I didn't have to have that one tattooed on my arm. We have to refer to that so much.
We could do probably a whole show on how to break down these HO6 policies and just all the information that goes into that, because it's a lot. Like most people, even myself, I get it, kind of glance at it and go, okay, great. And you don't think about it again until it's a problem and you need it. Then you're like, oh, I should have looked at this a little closer.
I struggle with loss analysis because, particularly on the condo side, because it tells you what area the owner is supposed to cover when there's an insurable loss and what area that the condominium is supposed to cover. And then you've got language in the HOA policy that's anti-subrogation language, and then you've usually got it in the governing documents. And so theoretically, I'm thinking...
What is that language?
Well, it usually says that you don't have the right to subrogate your loss and to go after the association. But, you see negligence lawsuits filed all the time, so I'm still trying to wrap my head around how to advise the client. Technically, the statute says even if it's your fault, that's the area they cover. Their carrier should be covering that. And here's the area that you cover, the unfinished drywall and in and the exterior of the unit.
I've got a question it's really off the wall a little bit, but what caused you to be in this direction as an attorney for condo associations?
That's a good question, period. I think for any attorney, like, why did you choose that particular area of law?
It just kind of fell into it. One of my last courses that I took at Stetson was a Florida real estate class. And we had to do like a long paper in every class. And I had a writing sample on condos and HOAs. I just got into that. And when I interviewed for my first job with Frank Friscia, I had that writing sample. I mean, when I went, I didn't know that they did condo HOA law. I thought they just did construction stuff. So it was kind of dumb luck when he started interviewing me. And I was like, oh, by the way, you just said you do condo HOA. Here's a writing sample on condo HOA. And I was with them for about 11 years and learned a lot.
That's good. What
about this question? What is the craziest thing you had to defend or litigate?
Or deal with?
It's craziest story.
Before I tell some stories, one of the as general counsel, you don't end up having to do a lot of the defense work because of your insurance policies. When the association gets sued, they're assigning defense counsel that's paid for by the insurance company. You pay the deductible. I'm oversimplifying the process.
Right.
But most of the time when I'm litigating, it's a case that I filed for the association, whether it's a violation enforcement or assessment collection. That's most of it, or suing a vendor that didn't perform on the contract. Crazy stories. And these don't necessarily...
Yeah, and I'm talking like somebody put up a prisoner of war flag in front of their house and the HOA went after them.
Do they, before you go on to that, do you ever see where the HOAs will negotiate or modify their fees? Like when you're sending out the demand letters before they have to be sued? Do they try to amicably work with them on that? Or?
Oh, absolutely. If I'm the counsel, I'm trying to advise that because there's no guarantees in litigation, and a bird in hand's worth two in the bush. So if you can eliminate some soft costs, take a little bit of hard costs, like you don't want to drive someone into bankruptcy because you're going to write it all off. You don't want to drive somebody into first mortgage foreclosure because you're going to have hard debt loss.
Yeah.
So if you can eliminate some soft costs and get it paid right away or in a short-term payment plan, that's pretty prudent. Crazy stories. At the some of my peers have had to litigate emotional support squirrel cases.
Oh, gosh. Yes. That's probably a big one right there.
All kinds of situations. Like I said, at least twice a year, I'm sending a letter telling folks not to shoot each other on the common areas, and that's probably violations of the nuisance clause or criminality clause.
Welcome to Florida.
We have to send people letters telling them not to film porn on their balconies. All kinds of crazy stuff comes up.
That's
it's
funny.
kind of wild.
That's funny.
Wait, did you say not to film porn?
That kind of thing happens in downtown Tampa occasionally.
Don't tell me the name, just give me the address.
You have
You
a
cannot do
good
that.
faith obligation to make sure that the violation exists.
So what, in your opinion, this is a good one too, right? And I know it's like, this is like such an open-ended, wide, vague question. And you have, like, for example, even as extreme as what Pat said, where you have these voluntary HOAs where they wrote it with a good intention of having deed restrictions compared to like the major new CDD HOA communities that are a little more tight-knit run. When do you see it's necessary to update or amend some of these governing documents, whether it's the bylaws or the CCRs? When does some of the times you're like, yeah, we need to amend this?
Usually it's because there's a provision you don't like. I have a lot of clients come to me and they say, well, we haven't updated in 20 years. I'm like, well, why are you updating? Why are we? Let's not make superfluous changes. Let's make sure they're necessary changes. So usually I get the client to make a list of things they think need changed, and I'll make a list, and then we'll have a quick meeting. We'll pare it down, prepare some amendments. Usually what clients want to do is more extensive than I think is necessary, and I'm not going to take them for a ride. Basically say, I don't think you need to do all that. Here's the 5 things I think we'd do, and we can get that done in a few hours, and it's done. So it really depends. Most of the time it starts when they don't like something, like they want to change leasing provisions to make it less or more restrictive. And then there's, you don't want to amend your governing documents, I don't think, to track the statute every year, because it changes every year, and some changes are going to apply to your association whether you change the governing documents or not. So sometimes certain statutes supersede your governing documents. Sometimes they don't apply to you. So,
have the short-term rentals been a big thing in a lot of the communities where you work, where people really want to amend to allow shorter-term rentals?
The biggest thing I'm seeing is folks that are wanting to prevent institutional ownership of massive amount of blocks of property in their community and or limit short-term rentals. So those are the 2 biggest things I see clients coming to us for.
I personally think that minimum time frame to own before you can rent is a good one.
Yes.
I think it's a good practice, because I saw that happen in one of the neighborhoods I lived in for 20 years, where the bylaws were written in the 70s. They were pretty loose. A lot of people bought in that community because they like that. So, for example, my neighbor that I had probably 20-some years ago had an RV, and the bylaw, a lot of people would buy in that community because the lots were big and you had plenty of room to park a boat or an RV or whatever there. And they were just enough restrictions to keep the neighborhood nice, but not so over the top to be annoying to homeowners, if that makes sense.
Absolutely.
And so they were always trying to enforce stuff that the bylaws really didn't allow for. And they were constantly trying to change it, and the homeowners would never sign up for it. They're like, nope, we're not going to do it. And the neighbor on the one side ended up taking the HOA to court over their RV because they gave them a hard time about parking it. And ultimately, the long and the short of that litigation, because it went all the way to trial, was the judge basically told them, you can't have your cake and eat it too. So they are allowed to park it behind the fence, but not in front of the fence. Kind of was what so they can't complain about the top or any of that.
Glad you mentioned fences, because they changed the statute a couple of years ago, the HOA storage statute, where basically if you can't see it behind the fence, even if it would be a violation otherwise, you can't do any enforcement action. And you mentioned the commercial vehicle ban earlier. Now it's really tough to enforce commercial vehicle restrictions. You know, I think I've mentioned on the show before, there's a 1970s appellate court case called Kaufman. And it essentially stands for the idea that whenever your governing documents were filed and your community founded, that version of the statutes, with some exceptions, applies to your association. So some people are still enforcing commercial vehicle restrictions if they don't have Kaufman language in their governing documents, which make the governing documents move with statutory changes.
That's
So
good
you're
to
saying
know.
it's hard to enforce that commercial vehicle?
Depends on when
Absolutely.
it's
It's more
written,
difficult
though,
now.
right?
Because we have several of those, and
Doesn't-
our neighbors want to
that-
enforce it. And I guess
Doesn't it
can't.
depend on when the bylaws are written, right? So the newer communities, it's harder to. I mean, they're going to be a lot easier to enforce that than the older ones.
The key analysis is not just when it was formed, but do you have Kaufman language? Kaufman language essentially means that you have language tracking the statute as it's amended from time to time, either subjecting the whole set of governing documents to Kaufman or individual clauses. So that's something you've got to look for. I, for one, am not sure I would, even if I didn't have Kaufman language, I don't like the risk of going after the commercial vehicles because of the statute change. I'm not sure a judge may not understand that nuance of the argument. It's something you could lose, and so I'm a little bit more conservative. I let the client know the risks, and if they still want to pursue it, then I'll be your huckleberry. But
Yeah.
Some of my neighbors just want to call a deputy, though.
Well,
What would happen?
right,
What would happen if you called a deputy?
Well, I had a friend. They won't get involved in that. They'll say it's civil.
Oh, okay.
Do nothing. They're going to say it's civil. Sorry, I can't help you. I'm
Right.
going down the road. But I had a friend of mine trying to rent her property and literally lost the tenant we had secured because the HOA wouldn't allow any type of writing on the side of the vehicle.
yeah, it's tough. I think some of those rules are kind of antiquated because a lot of people now are having vehicle wraps or advertising their vehicle on the. So I mean, I like the idea of certain things that are pretty egregious being banned, but it definitely should be scaled back a lot more. Now it almost has to be like a 12,000-pound vehicle or like a fire truck to be, you know what I mean?
Wow.
Like it points to a commercial vehicle statute which defines commercial vehicles, and I don't remember the weight, but it's a massive vehicle. So it's basically eliminated the ability to enforce commercial vehicle.
What about the cab of a semi parked up in the grass facing your fence?
I'm glad you mentioned that. So
He's like,
if your rules say that you can't park in a particular vehicle, then the analysis is, well, you're not supposed to park in that spot, and it doesn't matter what type of vehicle it is. So a lot of these governing documents say you had to park in the driveway or in the garage, and so you can park this commercial vehicle now probably in your driveway, but it doesn't mean you can go park it in the middle of your grass lot or up on the curb or by the drainage pond.
My neighborhood used to be pretty.
I hear you.
well, and I think, there's some draw to people that want to live in a community that's not as restrictive, right? We'll have people that come to us and they'll say, I don't want to live in a community with any restrictions at all. And then you start looking and you're like, okay, that's most of the neighborhoods, especially all the new construction. So that a lot of them end up buying in areas like Carrollwood because it's not as strict, but there's some rules to keep it nice, which I think is a pretty good balance,
Absolutely.
I think it's a good way to do it. Some of the newer communities are a little over the top. I think they're a little overzealous in terms of like enforcement action and trying to keep it nice. And I know you want to do that, but
it really depends on your board. Some are more reasonable than others. And the great thing about the process is if you participate, you can change the board through elections annually, and there's a recall process. You go get a simple majority of the community to sign ballots, and you can kick anybody off the board you want.
yeah.
We're getting close to the end. What is something you want to touch on that you're going to probably get in the car, hit yourself in the forehead, and go, I wish I had brought that up?
I think what I kind of touched on earlier, the vitriol going back and forth between members and board members, I mean, it grinds business to a halt. When you're having to read hundreds of nasty emails all day long, then you can't do the real work of the association. And I challenge folks, send a couple of emails, challenge the board, tell them you're unhappy with something, but then let it go. If they don't make the decisions you want them to make, you have remedies. Hire an attorney and send an offer to mediate. Do a recall. Make sure you run for the board next time and get them voted off the board. But sending 1,000 nasty messages telling them how much you dislike their decisions is just costing your association a lot of money. And then the manager and the board do not have time to conduct the real business of the association.
It doesn't help anything. It's just petty. Like you say, if you want to just sign up for the change or don't complain about it.
I'm getting thicker skin because clients bring me in as a heat shield for board meetings, so there's somebody else to get yelled at.
Yeah.
And I probably delete and respond to probably 75 emails a day that are just attacking the personal character of myself or the board or management. And I think we're in a climate where folks, I mean, it's okay to disagree with someone, but go after a better approach, a better remedy. You're not accomplishing anything by being nasty to the people that are volunteering for free to run this association.
Have you found a way to sort of sizzle and calm down some of the combativeness that people show up to the HOA meetings with?
I've learned not to combat back. Mm-hmm. People are entitled to their opinion. They have a different vantage point than I do. So thank you for your comments. I will find out how the client wants to proceed. God bless you and have a wonderful afternoon.
I love that.
How many times out of a month are you in an association meeting on a Tuesday night at 7 o'clock?
I go to 2 or 3 HOA meetings in the evening every week.
It's like more than I would like.
Yes.
So before we, I guess, wrap up the show, we touched on it earlier, and I think it's such a great thing to talk about. We could probably make a whole show out of it, but I'd like to just sort of wrap up with this. When you're talking about the support animals, whether it's a service animal, emotional support animal, what are your thoughts on that? Because there is definitely not enough language, I don't think, in the statute unless something's new. And it's such a, like the attorneys, when we talk to them, when it comes up on our side and people are like, well, I have this service animal, like it's something you don't really want to be on the other side of in terms of discrimination. But what are your thoughts on that? Like, because I'm sure you've seen this come up more and more and more.
I mean, I get emotional support animal or service animal questions every week. Sometimes we're crafting policies on how to evaluate. Sometimes it's, hey, we got this one. Should we allow it? One thing I tell clients all the time is there's no such thing as a pet-free community anymore. Mm-hmm. I mean, if you have any kind of disability or ADHD or whatever the case may be, you go to your therapist, you go to your health provider, you get a note saying you have a disability-related need for the animal, and boom, the HOA has to let it go because there's great liability. You will get sued. So you just leave it alone. And now, that person having an ESA or a service animal doesn't mean that they can let it run unleashed, doesn't mean that they don't have to pick up after it, mm-hmm. doesn't mean that it's allowed to bark incessantly 24 hours a day. You can still pursue other violations, but its status as an animal doesn't make it a violation. Right. It's technically not an animal under the statutes. Correct.
Yeah, the way I guess the law sees it, for lack of better words, is it's like a person in a wheelchair, you saying that they can't have their wheelchair in their home. It's looked at the same way.
And you really can't dig into the disability.
Correct.
You ask for the note and leave it alone. As long as they're saying there's a disability-related need for it, then your inquiry is over.
We don't do any property management, but we do tenant location, which is where we place a qualified tenant in a property. And we had one lady that lived on the property, and so she had an accessory dwelling that was like separate, but it was still on the same land, if you will. And she had a lady that had a service animal and was trying to do that, was trying to dig into it and ask more. And I said, no, we're not doing this. We're not getting on this side. Like if she's got a letter from her doctor and saying it's a service animal, we're not asking any more questions.
I do the same kind of thing with tenant approval clauses. There's very few good reasons in a condo or HOA to deny a transfer or a lease. Recent severe criminality is the only things that I can, like finances, I don't think are a good thing. Let the owner worry about that. But I'm not a big fan of transfer and lease approval clauses because I think there's great exposure for the association when you deny someone.
So it's funny, the condo that I'm under contract to buy now, It's one of those things where I would go back and read the language very carefully, right, word by word, like an attorney would, which is what you guys do. And I was out on the trip, and Adelisa actually read it, and I was so proud of her. Like when the way she responded, I was looking at it, and they have in their bylaws that you have to have 10% to basically buy it. Well, I'm putting 25% down on it, but my escrow deposit was not 10%. We had an initial deposit and a secondary deposit after inspections, and the CAM manager on site kept asking for an upfront deposit to be sent to the title company. And we responded back and we're like, no, it doesn't say upfront anywhere. Like you're adding language to what the bylaws are saying, and it doesn't say that anywhere. And so I responded back and I said, I'm going to ask my lender to chime in here because I'm more than meeting the down payment requirement, and you're not renegotiating my contract for me.
So was this an HOA asking for a deposit?
So the CAM manager that's on site, I think the unit it's around $200,000. I gave them, I think, a $5,000 deposit and then another deposit later, but it wasn't 10%. But I'm putting 25% down on the unit, and they wanted me to put 10% in escrow with the title company. And that's what they were trying to push and enforce. We're like, no, that's not what the bylaws say. And the lender they have verified my funds, and they verified that I'm meeting your requirement. I don't have to send it up front, and you can't renegotiate the contract. And I sold the unit across the hall, and they were paying cash. And it was kind of the same thing where they were asking for an additional escrow deposit, right? When we're representing the buyer, we want that to be as low as possible in case there's a dispute. They don't have to fight for their money later, or it's less money anyway.
Right.
And they were like adamant on, we're not issuing an approval for you as the owner until you put in this additional money.
Too many clients don't want to use their professionals to see if what they're doing is legally correct. So sometimes you don't see contracts or issues like that until it's a legal dispute where they should spend, a 0.3 or 0.4 on their attorney on the front end to make sure they're doing these things right, and it prevents litigation on the back end.
Yeah, I just responded pretty simply and matter of fact, and it was interesting how that kind of went away. But the cash buyer I had, they were pushing for this and pushing for them to give an additional deposit. And I said, here's the thing, you're closing next week. It's kind of stupid. Like, I would just wire your money because you're going to wire it anyway.
Right.
But yeah, it was interesting, literally trying to renegotiate the contract.
Well, I'm glad we got to come here today. This has been fun.
Yeah.
I've learned a lot.
Any final thoughts on this as we wrap up some of the stuff you should be asking your attorney?
Just be thoughtful, pay attention to your governing documents, and seek the advice of experts.
Yes, definitely. Well, this is Tampa Home Talk, and I'm your host, Katrina Madewell. It's been very fun hanging out with you today, Mr. George Root.
Thank you, Katrina, for having me and letting the Stockholm Law Group join your show. I appreciate it.
We're so glad you're back. Would highly recommend them if you are in the care of an HOA, board of directors, or anyone that needs maybe some better legal counsel on a retainer. I would highly recommend you give them a call.
Thank you.
This is Tampa Home Talk. We're out.